Well, hello and welcome. This is the Employment Law Show. Good to have you along for the half hour. John Scholes here. Beside me, Lior Samfiru. He is the co-founding partner, Samfiru Tumarkin LLP. They're the most positively reviewed employment law firm across the country, coast to coast to coast. You can check that out for yourself. Lots to get through on the show today, Lior, including 5 fast facts about overtime pay. So stick around for those. Are coming up a little bit later in the show. I'm going to give you some contact information. You want to reach out to Lior's team anytime you would like. Have a conversation. Learn lots more than you get here and on the radio show as well. 1-855-821-5900. Help at employmentlawyer.ca, and a website built just for you, structured a couple of years ago, is pocketemploymentlawyer.ca. It's free, it's anonymous, there's all kinds of learning to be done there, and wrapped up into it as well, I know we use it on every show, Severance Pay Calculator is within that website, pocketemploymentlawyer.ca. But we'll get to some phone calls, we'll get to our fast facts, Lior, but we always start off with the week that was, pal. What's going on with you?
Well, John, this is, as you know, the show about the rights that you didn't even know you had, but you actually have them. And unfortunately, they don't teach employment law in schools. You know, you can get a job, but no one actually sits and teaches you what your rights are on that job. You have to educate and inform yourself. Well, we're here to do that for you, or at least to help you do that, by telling you the things that you need to know, the common things that I deal with as an employment lawyer that I see that I think people need to know and understand. So hopefully, every single time you watch us on this show, you'll leave here, you'll turn off the TV knowing more than you did about your rights. We spend so much time at work, John. We do more at work than we do anywhere else. So it's important that we know what our rights are. You know, when we drive, we know the rules of the road. We know what the law says in terms of, you know, speeding and stopping. Yeah. Well, so many people don't know the same rules when it comes to their job and their work. Well, now you can know. And if you have any questions, if something that we say here triggers a question, an issue in your mind that you're dealing with, don't let that fester. Reach out to me off air. We'll give you that contact information throughout the show so that we can have that private discussion. You'll be better off for doing that. But as John said, I always like to start off the show with a situation that came across my desk. Now, John, the big issue, and I don't think you'll be surprised, still has to do with vaccines and vaccine mandates. But specifically now is more and more governments across the country are relaxing vaccination rules and vaccination passport rules. I've had employees say, well, wait a second. What does that mean for my employer's vaccine mandate? Does that give me new rights, or can they still tell me that I have to be vaccinated or else? So let's talk a bit about that. I've been asked that several times over the past couple of weeks, so I think it's really important. But to answer that, I'm going to actually turn it on its head a bit by saying that regardless of the relaxing of vaccine mandates, your employer does not have the right to suspend you or to let you go without pay if you don't get the vaccine. They can let you go because an employer generally can let someone go pretty much for any reason, but severance has to be paid. And the same thing happens now. If the government says, well, we don't need vaccine mandates anymore, if your employer says, hey, I don't really care what the government says, I've chosen as an employer to have vaccine mandates in the workplace, ultimately, if you don't do what they say, you may lose your job. But, and this is the big one, they'll have to pay you compensation. They'll have to pay severance. That can be as much as 2 years' pay. 2 years' pay. That's a lot of money. Now, a lot of employers are not doing that. They don't realize that. They think they can just suspend someone or let someone go without paying them anything because of their vaccine status. No, they can't do that. That's where I get involved in my team. So ultimately, what the government does is not necessarily going to impact you here because of the fact that in most cases, if you lose your job, yes, you're going to be owed severance regardless of your vaccine status.
How do those facts change if you're regulated federally or an employee of the federal government? They say you got to be vaccinated. If that's still around much longer, who knows, right?
Correct. Now, if you're in a workplace where the government is saying to work in this workplace, your employer has to have you be vaccinated. If that's the case, so there's a vaccine mandate that applies specifically to your workplace, then in that case, your employer can let you go if you're not vaccinated without any compensation because it's not your employer's decision. It's not their choice. The government has made that choice. Now, for many employees, that doesn't apply. There are very, very few government mandates that apply to workplaces in Canada, and those are becoming even fewer, okay? So don't assume that there's a government mandate that applies to you. In most cases, there isn't. If you're not sure, let's talk about it, because you don't want to walk away from legal rights that you have.
Yeah, I think that whole point you made off the top about severance is really interesting. Whereas if there's no federal mandate, if you're just working for a Joe employer and he's like, well, the government says, so you're not doing it, so I'm letting you go. It's an interesting distinction where you say they can let you go, and they can let you go if you're wearing a blue tie or if you have glasses, but they have to pay a severance. It's not how they let you go, it's what they give you at the end, right?
Exactly. Your employer can have a policy that says from now on, anyone that works here must drive a sports car. I mean, it's a silly policy to do that. Other than John, some people may not be happy about that. I mean, it's a silly policy, but they can do that as long as they pay severance to those employees that choose not to buy a sports car. I know I'm equating sports car with vaccination. It's not the same thing. But from a legal standpoint, ultimately, it comes down to whether or not your employer can let you go without compensation. And with respect to vaccine status, in most cases, is no, they cannot do that.
EmploymentLawyer.ca is a website you want to go to. While you're there, you can find a radio show across the country where Lior and I and other members of his staff have been doing it for 10 years. All kinds of phone calls. Everybody needs stuff to know. They have questions about their employment law rights. So we take the phone calls, answer them on the radio show, of course, but we cherry pick a few, Lior, every show and play them back here. I want to get to the first phone call for today right now.
For one of the company for 8 years, got laid off on just before the New Year's. So it was because of the COVID. So because I was kind of a site manager for one of the sites, so they didn't need me there basically. They gave me 6 weeks of notice, 3 weeks with pay, and then 3 weeks without pay. I was just wondering about the severance package. Like, am I eligible for anything?
How long did you work there for?
About 8 years.
Yeah. How old are you?
52.
So this is a situation where we're asked to answer a very simple question. After 8 years as a site manager, does this 52-year-old person get more than the 6 weeks that he was offered? And my gosh, that's not even close. But let's start with the idea. It touches what I said earlier, that his employer can let him go. He may not have done anything wrong. He may have been the best employee for the 8 years that he was there. His employer can still let him go if they pay him proper severance. Where you don't get proper severance, that's what a wrongful dismissal is. So wrongful dismissal really has to do with severance. You may have been let go for the best reasons in the world. You're still wrongfully dismissed if you did not get the severance that you're owed. And 90% of people, when they are let go, are in fact wrongfully dismissed. But let's turn back to this person. So I've already kind of told you, I've spoiled it, the fact that he's owed a heck of a lot more than 6 weeks of severance after his years of employment. But rather than me tell you the exact amount, let me show you the exact amount, and let me show you how you could do that yourself. Let's go to pocketemploymentlawyer.ca, and let's use our severance calculator tool that you'll be able to find there, and let's exactly see how much this person is owed. So we know that this person has been there for 8 years. He's a site manager, 52 years of age, and his employer very generously has offered him 6 weeks pay. You can see at the bottom that this person could be owed as much as 14 months pay, 14 months, not weeks, months pay. So the difference, the delta there is between the 6 weeks and 14 months. That's massive, that's huge. And by the way, though, that's not unusual. I see this exact scenario or variations of it every single day, multiple times a day. So that's why we have this show, and that's why you have to call me or go to pocketemploymentlawyer.ca if you lost your job.
Interesting point made in that phone call, Lior, with this gentleman. And I mean, even though the employer's way short of what they owe him, they did kind of split it up between working notice and pay, which that is okay to do, right?
Absolutely. So an employer has a certain amount of severance they can pay, or have to pay, but instead of that, they could give you sufficient advance notice. So for example, if you're owed 9 months severance, as an example, your employer can simply give you 9 months advance notice of the termination of your employment. That's called working notice. As long as the employer gives you the sufficient amount of notice, they don't have to pay you severance. They can also do a combination of the two. So if you're owed 9 months severance, they can say, well, we're going to give you 3 months notice, and then we're going to pay you for another 6 months. So the total is 9 months. In most cases, when employees get notice of termination, they don't get enough notice, meaning the employer has to make up the difference by way of severance.
I think I mentioned the website, terminationquestions.com. It is yet another outlet for you to ask questions to get them answered by Lior and his team. Before we break, I want to slide one in here quick. Lior, this one from Miriam writes in, says, I took a year-long maternity leave contract position with the promise of a permanent job at the company after the contract ended. They ended up terminating the contract 4 months early after telling me that I wasn't suited for the position. Am I owed anything?
So this is what we call a fixed term contract. So a fixed term contract is when you sign an employment agreement for a specific period of time, 12 months, 20 months, 3 years, a specific and definite period of time. Now, the general rule is this. If you are on a fixed term contract, but your employer lets you go before the end of that contract, they still have to pay the difference. They have to pay the balance of that contract. So in this situation, if she was on a 12-month contract and her employer let her go with 4 months to go, 4 months on the contract, they still have to pay her for those 4 months. So the employer is not saving any money by letting her go. Her employer still has to pay her. And the fact that they feel she's not a good fit does not allow them to avoid paying that severance. So with respect to fixed-term contracts, the severance rules are different. You may not be owed the same severance as everyone else. You're owed severance that pays you for the balance of the contract. And you know the story, John. I love telling it. I once did a case. I had a client that was owed several years, over 5 years left on his contract. And he had to get it paid because, hey, that's simply what the law says.
Nice. We'll get to our fast 5 facts about overtime pay, but we got to take a break first, so we're going to do that now. In the meantime, 1-855-821-5900. That's the number to reach out. And help@employmentlawyer.ca. The Employment Law Show continues. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Employment Law Show. Thank you for joining us again this week. Lior Samfiru beside me, John Scholes here, reaching out 1-855-821-5900, help@employmentlawyer.ca. Want to get into these, Lior, right away. 5 fast facts about overtime. A lot of this is either not enough information people have or just the wrong information, so let's clear some of that up. Number 1, an employer cannot force you to work overtime if it falls outside of your regular work hours.
That is a very common situation or question that I get, can my employer make me, force me to work overtime? And generally speaking, the answer to that is, well, no. You have your regular hours of work, and those are the hours. And just like you can't decide to change those hours, neither can your employer. And you can say no, and your employer cannot discipline you for not working overtime. That said, keep in mind that an employer ultimately can let you go. We've said that earlier, pretty much for any reason, as long as severance is paid. So they can say that, well, if you don't work overtime, then we're going to let you go. We're going to have to pay you severance. That severance can be as much as 2 years' pay, but we're willing to do that. What they can't do is let you go without compensation. The other thing, though, is you want to do is look at your employment agreement. Some employment agreements say that your hours of work are Monday to Friday, 9 to 5, but we, the employer, have the right to require you to work overtime hours. If your employment agreement says that, then yes, your employer may have flexibility to require you. But in most cases, an employer does not have the legal ability to require employees to work extra overtime hours.
Okay, here we are, overtime fact number 2. This one I find interesting. Managers may be owed overtime pay in some situations. Maybe.
So the general rule is that a manager is exempt from overtime. So if you're a manager and you work a certain number of hours, even if it's more than your regular hours, an employer does not have to pay overtime. And some employers understand that and say, wait a second, managers are exempt. So let's call someone a manager and then avoid paying them overtime. Wait a second. If you're a manager in title and nothing else, then you're not actually a manager, meaning you have to get paid overtime. So the question becomes, are you truly a manager? Do you have people that are reporting to you? Do you manage people? If the answer is yes, yes, I do, well, then yes, you're exempt from overtime. But if you have the title of a manager, but you don't actually perform managerial functions, you're not a manager, and then yes, overtime has to be paid. The other things, other time that a manager may be owed overtime, even if they're a true manager, is if the employment agreement specifically says that we will pay you extra hours if you work more than 45 hours a week or whatever it is. So the employment agreement is extremely important to review and understand in that situation. But yes, there are cases and situations where a manager gets paid overtime because they're a manager in title only.
Fact number 3 about overtime, and this one always comes up in the phone calls and emails: salaried employees are owed overtime.
So it's easy to think that overtime is only for hourly paid employees. But what about salary paid employees? I don't get paid by the hour. I get a certain amount of salary a week or a month. Do I get overtime? Absolutely, you do. You absolutely get paid overtime. How is it calculated? Well, you have to get paid time and a half for your overtime hours. So we simply calculate your hourly rate by taking your weekly pay, dividing it by the number of hours before you qualify to overtime. Depending on your province, that could be 40 hours or 44 hours. And then that gives us an hourly rate. And a time and a half is your overtime rate. So bottom line is, yes, salaried employees have to get paid overtime, have to get paid time and a half if they work beyond that threshold, as long as you're not a manager or working in an exempt position. So there are some positions, as you know, John, that are exempt from overtime, like lawyers, doctors, nurses, some other professions as well, IT professionals. But if you're not working in an exempt position, even if you're on a salary, yeah, you better believe you're owed overtime.
We are doing our 5 fast overtime facts. Number 4 is this: your employer can't stop you from working the overtime if it is needed to get your job done.
Well, I think we're saying can't stop you. I think what we mean to say there is they can't avoid paying you. So, I mean, they could try to stop you. That's not the point. The point is, if you worked overtime, even if your employer says not to, but you had to do it to get the job done, your employer still has to pay you for that work. So an employer can't say to you, well, wait a second, we didn't approve it, or we told you not to work it, so we're not going to pay it. Absolutely not. If the overtime is worked, and if it was legitimate, then your employer has to pay you your overtime hours. Now, if your employer specifically told you don't do it, and you did it anyway, that could become a disciplinary issue. They could potentially discipline you for not doing what they've asked you to do. That said, they still have to pay you for that overtime hours. So an employer can't avoid that by coming up with an excuse about the need or about what they said to the employee to do.
Let me just sidestep that last point that you just made. They can discipline you. Can they go as far as letting you go for doing it? And if they do they have to pay a severance for it?
So for it to be a disciplinary termination, in other words, to let you go without any compensation, they would have to show that you've done a bunch of stuff wrong and that they've documented. So if you worked overtime one time when they told you not to, that's never going to be cause for termination. That's never going to allow them to let you go without severance. But if you've done it a few times and every time they warned you don't do it, you'll lose your job if you continue doing it and you do it anyway. Well, yeah, at some point they may be able to let you go for cause without severance, but that's going to be very, very difficult for the employer to do.
5 fast facts about overtime, Lior. Last one is this: employees who have not been given overtime pay can pursue severance pay. How about that?
So let's be very clear. When you have a job, the deal with your employer is actually very straightforward, right? I come into work, I do my job, and you pay me what you owe me. It's that simple. So if your employer doesn't pay you what they owe you, that's a breach of terms of employment. Maybe they don't pay you your salary. Maybe in this case, they don't pay you your overtime. So the failure to pay an employee what the employee is owed could result in a constructive dismissal. So if you say, well, I've had enough. This employer never pays me what they're supposed to. They don't pay me my overtime. I'm out of here. Well, that resignation in the eyes of the law is actually a termination. It's a constructive dismissal. So you're going to be owed severance even though you're the one that's left. you're the one that left the workplace, because an employer has to do what they're supposed to, and if they don't, that's a constructive dismissal.
How far can you go back if you have overtime that hasn't been paid?
So if you're, first of all, to recover unpaid overtime, you can go back 2 years. Okay? So if today is a specific date, you can go back 2 years from today, and any overtime that's owed to you over that period of time, you can get. And in some cases, people decide not to pursue their overtime because they don't want to get into a conflict with their employer, and they decide to pursue it when they're let go. You can certainly do that, but keep in mind, the longer you wait, the more likely it is that you will go beyond that 2-year limitation period.
If we discussed anything about overtime, you still have some questions floating around in your mind, reach out. No problem. 1-855-821-5900. help@employmentlawyer.ca. Lior, want to grab one more phone call from our radio show before we take a break? It's coming up right now.
I was offered a new job recently, and the offer essentially says that if I'm terminated without cause, they would give me 2 weeks per year of service, up to a maximum of 12 months. And I guess I'm just wondering if is that a common provision?
So he's working, John, and his employer says, I want you to sign a new employment agreement. Should he be concerned? Should anyone be concerned in that situation? My gosh, absolutely yes.
You bet.
If you're working and your employer is handing you a new piece of paper to sign, be concerned. It's not a good thing. It doesn't give you more rights. It takes away rights. What you need to understand is that even though you have good rights, you also have the ability to give away those rights. You can, and oftentimes people do that in an employment agreement. Now, specifically in this situation, if his employment agreement says 2 weeks per year to a maximum of 12 months, that's not good, because the law would provide him for significantly more than that. So what this does, this termination clause does, is it tries to limit his entitlements. Generally speaking, if your employment agreement addresses the issue of termination, it's to limit your entitlements, not to give you more entitlements than you have. That's true in 98% of the cases. So be very concerned. Don't sign away your severance rights. If you do, that could cost you at some point tens of thousands of dollars.
Want to get to another phone call, Lior, but break time is first, so we'll do that, come back and do one more and some other things as well. 1-855-821-5900. That's the number to reach out anytime. pocketemploymentlawyer.ca, free and anonymous website built just for you to use. And finally, the email address, help@employmentlawyer.ca. We'll continue. This is the Employment Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Employment Law Show. A few minutes to go here, Lior. Just enough time to at least squeeze in one more phone call from our radio show. It's coming up right now.
My wife, she's been with this company for about 25 years. She's vice president of sales and marketing. It's not the job, it's the issue. It's the environment. The person she reports has been undermining and all kinds of different emotional things that's been going on. And my wife wants to quit. I said, no, you're not going to quit. There must be something here legally that we can do moving forward. Is there something here that she can look at?
Yeah.
Workplace harassment, workplace bullying, what a bad way to potentially end a 25-year employment relationship.
Yeah.
So in this case, what she absolutely has to do is, number one, find a way to document what's been happening. right? Because if there's a perpetrator, they're not going to admit it. They're not going to say, yes, we did it. Too bad. Sorry about that. No. So it's going to be up to her to document this, to have some way to prove it. So either having a recording or having emails or having a journal or having a witness. There's just a number of ways where you can document that harassment. Once you have that, once you have the proof, you put the ball in the employer's court to do something about it. You tell HR, you tell the owner, tell the right person in your organization, and put the onus on them to now deal with it as they're legally required to do, okay? They have to investigate and they have to take it seriously. If your employer won't do that, if they drop the ball, they don't care enough to intervene, at that point we can look at this as a constructive dismissal. So even though you leave, that could allow you to get severance as if the company let you go. Now, we know that in this situation, this person has been there for 25 years. The question becomes, if this was a constructive dismissal, what would she be owed? Well, let's do what we've done before. Let's go to pocketemploymentlawyer.ca. And let's use the severance calculator tool, which, by the way, anyone can use free anonymously in seconds. So we're going to go to pocketemploymentlawyer.ca. We'll plug it into the severance calculator, and let's see what that gives us. So we know she's in a senior role in a vice president position, been there for 25 years. Her employer is not offering her any severance pay because we're looking at this as a constructive dismissal. What is she owed? You see at the bottom of the screen there, right around 24 months pay. 2 years pay. The big factors, of course, being the fact that she's been there a long time and she's in a senior position. So that's what's at stake for her. And the same with you, by the way. If you're being bullied, mistreated, and you end up leaving because of that, yeah, you may be owed severance. That may be a constructive dismissal. Although before you leave, before you quit, you want to talk to me before you pull that trigger.
Got to think about that. If you looked at that number there, if you caught it $125,000 a year, 24 months, that's $250,000, and she was going to resign? No way. No way.
You got to do this properly. There's a lot at stake. You may not be making $125,000 a year. You may be making $30,000 a year. It's still a significant amount of money that you are owed. So it's important to do this right.
One more shot from terminationquestions.com. Lior, before we wrap, here we go. This is from Kwan. Says, I've been on a prescribed medical leave for the past few months. I've communicated with my employer throughout and was assured I would be accommodated when I returned. Last week, I was told my position had been filled by a new hire. Can they do this?
So first of all, when you assess your ability to return or whether you have a job, you assess that at the time you're ready to return. And what I mean by that is if Kwan is still off work because of a medical condition, what his employer is doing in the meantime is irrelevant. Okay? Kwan needs to focus on getting better and getting healthy. And when he is ready to come back to work, he tells his employer, and at that point, his employer needs to try to find him a position, either his old position or a similar position if the old one doesn't exist anymore. And then and only then, if there is no position and the employer has tried looking for one, can the employer terminate employment with severance. But I wouldn't worry about what the employer is doing right now because Kwan may not be able to come back to work for another year. So it doesn't matter what the employer is doing now. I wouldn't worry about it. And as an employer, remember, that if you have an employee that's off on a disability leave, if you don't take them back, you're going to owe them severance. And that, as we saw previously, can be as much as 2 years pay. And
as far as Kwan coming back, it's all under the basis of his medical approval from his doctors, right? Always. The
doctor is judge and jury when it comes to the ability to work. Kwan's doctor will decide when he can come back to work, how long he needs to be off, and what accommodation he needs. And his employer really can't do anything about that. So always, always get that doctor's note.
Done for another show. Thank you so much for your input. Want to reach out? 1-855-821-5900, the number. Email help@employmentlawyer.ca. And finally, the website, pocketemploymentlawyer.ca as well. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.